Number 5, failure to fund and understand your revocable living trust. Revocable living trusts are very, very common. Financial advisors, no matter what the state that you live in, will often recommend them because they can be a great estate planning tool. One of the problems with revocable living trusts is that people simply don't understand them because they don't really make sense. I mean, a revocable living trust, it's a legal document you sign where you've signed it, so you're the grantor, you're the creator of it. Grantor also is trustor, they mean the same thing. You're the trustee of it because you manage everything in it. And you're the beneficiary of it because you set it up for yourself because it was a good idea to make sure that you had a trust and you're in charge of everything. And it's revocable. So it's a pass-through entity tax-wise, which means it doesn't even need its own tax ID number. You don't need to talk to your accountant about it. It's just like you own the assets outright, but yet they are and need to be titled in the name of the trust. So you're probably saying, why would anybody do that? Well, there's some good reasons to avoid probate in jurisdictions that are not probate friendly. That's the main reason to have a revocable living trust. Another reason is to make sure there's a successor trustee in case you lose capacity. Yes, you need your durable power of attorney, but you'll have a successor trustee also to manage the assets in the trust. So you're avoiding probate where you don't want there to be a probate, and you're making sure that your trust is managed if you can't manage it. Sometimes you hear people say, well, you also want a revocable living trust because it gives you creditor protections. I can't speak for states that are outside of Washington or Idaho where I'm licensed. But what I can tell you is that a revocable living trust gives you zero asset protections in these states. So if somebody says revocable living trust, asset protection, your next question might be, how does that work? Help me understand, because at least in Washington and Idaho, that's not true. Given that a revocable living trust can avoid a probate, and who wants a probate if you can avoid one? What's the problem with having a revocable living trust? Well, again, the problem is oftentimes that people don't understand them. And if you don't understand them, then you don't know how to manage them. What do I mean when I'm talking about managing a revocable living trust? It requires ongoing maintenance. By that, I mean, initially you should have retitled all of your bank accounts into the name of your trust. You should have done a deed that puts your house and any other real property you own into the trust. And if you decide to set up a different bank account or buy a new house or whatever you do as life goes on and life changes, you must title the asset in the name of the trust. If you don't do that, the trust has no authority over the asset. And on your death, since it's not within the trust, you're going to have a trust administration plus a probate. And if you have a revocable living trust, you know that there is this backup will called a pour over will, because it will capture assets that aren't in the trust. And that frequently is a situation that revocable living trusts are not fully funded. So that definitely is a problem. Another problem with revocable living trusts is they might be set up with tax trusts in them. So on the death of the first spouse, that their estate tax credit amount, the exclusion amount, is captured by putting assets into this credit shelter bypass trust that's in the revocable living trust. The surviving spouse doesn't remember any of that, and it's, understandably. And then they don't go to a lawyer. Why? Because they don't have to. Because unlike a probate where you typically will seek out help from an attorney, if you just have a trust and everything's in the name of the trust, you might not do anything. And if you don't do anything, then the tax protections that were put in this trust to come into place on the first spouse's death don't happen. So that's another problem, is that people just don't understand and they don't seek help with what to do with their revocable living trusts. In Washington, in particular, one of the reasons that revocable living trusts are disfavored, especially by elder law attorneys who understand Medicaid and long-term care, is that revocable living trust cannot give you the benefit of an asset protection supplemental needs trust for the surviving spouse. If you recall earlier when I was talking about a will with an asset protection supplemental needs trust, and the couple with $1 million estate and $500,000 went into the trust created by the will through the probate for the benefit of the surviving spouse, that $500,000 is a pretty nice nest egg. That money will never be in jeopardy of creditors or long-term care costs or having to be spent down to qualify for Medicaid, etc. It is protected. With a revocable living trust, you cannot accomplish that result in the state of Washington. Washington will not honor any kind of asset protection supplemental needs trust for a surviving spouse that is created by a revocable living trust. That is the reason that revocable living trusts are disfavored if we are trying to do planning to protect assets against future long-term care costs.